Disqualified MLAs seek urgent hearing in Supreme Court against disqualification. Mukul Rohatgi requests urgent hearing in Supreme Court. Mukul Rohatgi is the counsel for disqualified MLAs. Supreme Court asks counsel to give information on petitions to the registrar to fix the date for hearing on disqualified MLAs plea. That's the big news that we are currently tracking at this moment. The disqualified MLA is now seeking urgent hearing in Supreme Court against their disqualification. Mukul Rohatgi requests urgent hearing in Supreme Court. Rohatgi is the counsel for disqualified MLAs, and the Supreme Court has asked counsel to give information on petitions to registrar. The registrar will fix the dates for hearing on disqualified MLAs plea. They had sought an urgent hearing from the Supreme Court on their plea against the then Speaker's order rejecting their resignations and declaring them as ineligible to be legislators again for the term of the 15th Karnataka Legislative Assembly. Supreme Court advocate Mr. K.V. Dhananjay joins me over the phone line. First of all, many thanks, Mr. Dhananjay, for joining us on this broadcast. Now, disqualified MLAs have sought an urgent hearing in Supreme Court against the disqualification, and Mukul Rohatgi, of course, who's representing the disqualified MLAs, has also requested urgent hearing in Supreme Court.
Correct. And I don't think the Supreme Court could really allot urgent hearing to them, because the Supreme Court has roughly 65,000 cases pending before it. And the disqualified MLAs have had their day in court earlier. What they wanted was to resign. What they did get is instead a disqualification. So it's got a very similar impact as resignation. So what kind of urgency can they possibly plead? The only urgency they could possibly plead is that they wish to act as ministers in the new government. And if that is going to be their argument, then the Supreme Court will slap them and send them away. Because you can't make that argument, because that argument is opposed to public policy. Short of that argument, they can't make out a case for urgency at all. So what the court has done now is to tell them, look, go to the registrar and then request with them, and maybe he will allot a date. So it practically amounts to the judges saying that we are not going to give you an urgent listing.
Right.
If you want a proper listing, go to the registrar and then make a case before them. And it's like any other case now before the Supreme Court.
Right.